I'm a consultant with GSN Immigration. I'm a level 3 advisor and OSC registered level 3 advisor, and I have been for the past 15 years or so. Today I'm going to talk about domestic abuse visa, sometimes known as domestic violence visa. This is a visa that gives a route to settlement. Please subscribe to our YouTube channel, and to get the latest information about visas and immigration, please press the bell icon. Now, domestic violence, domestic abuse, route to settlement. It's slightly complicated. If you have a visa as a spouse, as a civil partner, as an unmarried partner, and your partner is either a British citizen, somebody who's settled in the UK, somebody who holds refugee leave, somebody who holds pre-settled status, and if you are experiencing domestic abuse or domestic violence from them, which has reached a certain level of severity, there is a possibility that you might be able to apply for this route to settlement. There doesn't have to be physical violence, but of course there might be physical violence. If there is physical violence, and if you have been physically injured, it's a strange and nasty thing to say, but this makes quite good evidence to support your visa application. The way that it's structured is a tiny bit complicated. You might hold a first grant of leave as a partner. If you hold a first grant of leave, you can make the application if the application is going to be strong enough. You might hold extension of a partner visa. Again, you can potentially make the application. However, there is a slightly funny rule about this. If you're on an extension visa, according to the rule, you must show that you've experienced the domestic abuse or violence on your grant, your second grant, your current grant of leave. The way that the rule is written, if you can only show domestic abuse or domestic violence on the first grant of leave, according to the rule, you won't succeed. Now, I don't know how strictly the Home Office interprets this rule. Maybe there's some flexibility, but that is what the rule says. You may have had your first grant of leave as a partner, your leave may have finished, you may have become an overstayer. Even in this situation, you can still make the application. You can still potentially make the application if the evidence is strong enough. I keep saying this, it's very, very important. There's no point in making a trivial application. The abuse or violence must reach a certain level of severity. You can't say, I had an argument with my husband last night, he criticised my cooking. That's not going to work. You need something a bit stronger than that. Of course, physical violence is always going to be strong, and especially if you can prove it. There are other kinds of domestic abuse, and there's no particular list. I'll give you some examples. Extreme psychological abuse, bullying behaviour, controlling behaviour, shouting and screaming, anything like that. Sometimes the partner gets their relatives to join in the abuse against the victim. There's no real list of things that are relevant, but where the psychological abuse reaches a certain level, then you might be able to make an application. Of course, the question is, what is the evidence that you need? What evidence is going to be helpful? Well, if you've got physical injuries, you are well advised to take photographs of the physical injuries. You are well advised to go to a medical practitioner. You are well advised to get a report or a letter from your medical practitioner. If it is perhaps violence or perhaps not violence, but if you have called the police, this can be very helpful. It might be helpful because it could stop you getting beaten up, but it could also be very helpful because the police will give you a report crime number. This is very good evidence for domestic abuse application. If things reach a really bad situation, there might be a court order a court order to restrain your partner from coming to the family home, for example. This is very strong evidence. If the situation is bad enough, you might have gone to stay at a refuge for victims of violence or abuse. If you can get evidence from this is very good evidence indeed, and the refuge might write a very helpful report for you. Finally, in this introduction, let me tell you something very, very, very important. Probably when you think about domestic abuse and domestic violence, you think of women being the victims. This is often the case, but not always. Men can apply along with women, and the criteria for men are exactly the same as for women. You might be surprised to know that a fairly substantial minority of applicants for this route are men. Men get treated exactly the same, that there is no discrimination in that way. Now, for this application, there is no additional English language test. You will have passed an English language test already if you hold a spouse visa or civil partner visa or unmarried partner visa, but there is no additional English language test for this application, and there is no life in the UK test requirement. Processing times for this visa is probably around 6 months. Now, there is a fee for this visa, which is quite high, £2,389. However, that sounds a lot of money to a lot of people in those kind of situations. You can apply for a fee waiver if you can show that you really can't afford that. If you can show that to a satisfactory standard, the fee waiver application will be granted and you won't have to pay any fee, any visa fee. I'm sure you'd like to know, what kind of documents do you need to provide for this application? It's not quite like other applications. There's no set list. There's no specific list. You should provide whatever documents you can. I can tell you the sort of documents that will make the application strong. If the police have been called, a police report with a crime number, that's good evidence. If you can get a medical report from your doctor or a medical practitioner, that can be strong supporting evidence. And of course, especially if you've got physical injuries. If in an extreme case, there's a court order, for example, prohibiting your partner from visiting a family home, that is extremely good evidence. If you have stayed at a refuge because you were frightened of violence from your partner, frightened of severe abuse, you can get, or hopefully you can get, a letter or a report from the refuge. That's good evidence as well. And also, if you can get statements from witnesses, friends, people who know about the situation, people who are prepared to provide evidence, this can be good supporting evidence as well. Now, there is no specific list. You have to provide what you can. Stronger evidence is better than weaker evidence. These types of evidence, some of the types of evidence are stronger than others, but you must and you should get as much strong evidence as you can. Now, Mr. Shah, some of these issues are fairly complex, so I do understand and appreciate that. Have you got any questions you'd like to ask me? Perhaps we can clarify a few of them.
Yes, please. Thank you very much for providing such useful information, and I'm sure victim of domestic abuse will be able to use that information to help themselves and apply for their stay in the UK. I have a few questions and I will ask you one by one. We have been asked by a gentleman who's come to the UK on a spousal visa. He says he's just come to the UK on a spouse visa just 3 months ago, and he believes that he's a victim of domestic abuse. He wants to find out whether he can apply for indefinite leave to remain on this basis.
Well, if he's got sufficient evidence to show that it has reached a sufficient level of severity, potentially, yes, he can apply.
Great. That means the duration of how long this person has been in the UK does not play a big role.
No.
Perfect. Okay. We've also been approached by a lady. She says she came to the UK as a spouse of a settled person. and she is a victim of domestic violence, but she has only discussed the issues she has with a friend of hers. She has not brought that matter to her doctor or anybody else's attention. She wants to find out, will a supporting letter from her friend be enough for her ILR application on domestic violence basis?
No, it won't. You need more than that. Letter from a friend could be evidence. Letter from a friend or witness, it's probably not the strongest type of evidence, but it could be evidence. It could have some weight and value, but by itself, certainly not enough, no.
Sure. Thank you for sharing your answer on that. We've received another inquiry from a gentleman who says he's a victim of a domestic violence. Mentally, he hasn't been physically abused by his partner. The partner is a settled person in the UK. This gentleman says he receives different medication from the GP to control his anxiety and depression, and is also undergoing few treatments to deal with these issues. He's saying his wife does not allow him to work and is very controlling. Therefore, he does not have the money to pay ILR high fees. Is there a way that he can still apply without paying the fees?
Well, yes, there might be. He could apply for a fee waiver. If he can prove that he really can't afford it, then quite possibly he won't have to pay the fees. But can I say something else about this? You can't prove your case by showing all the drugs and medicines that you're taking. You can prove your case by showing that the level of abuse is sufficiently severe to meet a threshold. So even if you've been prescribed 120 different medical drugs, that in itself doesn't get the visa for you. I mean, it might be supporting evidence in a vague sort of way, but really to make a strong and successful application, you have to show that the abuse is sufficiently severe.
Sure. Thank you very much. We have a few more questions for you, please. So a lady has contacted saying her husband, who is a British citizen, is very controlling, and she is not allowed to make any friends in the UK. Her husband does not allow her to call back home to speak to her parents. She wants to know, is she a victim of domestic abuse?
She might be. Controlling behaviour is one of the terms of art that the Home Office use to describe a certain type of domestic abuse. The problem in this case would be for her to obtain evidence, because you suggest there's no physical violence. She would have to get evidence. The best thing probably, if she has friends or witnesses who can provide statements, that's probably the best sort of evidence she could have. She might want to get a doctor's report. That might or might not be strong, but probably that's the best sort of evidence that she's going to be able to get.
Sure.
And once it's something counterintuitive, but if it turned into a row, shouting match argument, I mean, in a way I hope it doesn't happen, but in a way I hope it does happen. If this happened and she called the police, then that would add on evidence to the case.
Sure. Thank you very much for sharing that information. A gentleman has contacted saying he is an overstayer in the UK and is in a relationship to a settled person, not married, unmarried partner, and a victim of domestic abuse. He would like to find out, can he apply for ILR based on this category?
Tell me, did he hold a visa previously?
He did, yes.
What visa was that?
He's been on spouse visa previously.
A different
partner.
Yeah.
And that relationship broken down, and then he has a new partner now. So he overstayed that visa.
When you say that the first relationship broke down, was it because of domestic violence or was it because of other things?
He's mentioned that was also because of domestic abuse.
How long ago was that, roughly, would you say?
I can check. So this was about 3 months ago, before he got into the new relationship.
Right. He might be able to apply for domestic abuse, domestic violence settlement visa on the basis of the first relationship. The second relationship wouldn't really count because he doesn't have any visa in connection with that. But there is no rule saying that you have to hold leave when you make the application. As long as you had leave as a partner in one of the relevant categories, you can still make the application even as an overstayer. But from the way that you explain it to me, I think the application would have to be based on the first relationship, not the current relationship.
Sure, because of the visa not being based on this partner.
Yeah, yes, exactly.
Perfect, thank you very much for clarifying that. Someone has approached saying they're married to someone who's EEA national and hold settled status under the EU settlement scheme,
Yes.
and victim of domestic abuse. They want to know what documents they should gather to support their application.
Well, I've tried to address those issues and there is no firm answer. You should provide any good documents that I can. If you remember the list that I provided, you don't have to provide all of those, but you have to provide as many as you can. And depending on what kind of situation it is, some of those documents are more easy to obtain than others. Let me say the really, really strong document would be court order. That would be really strong evidence. Police report could be good. Medical report could be good, but it depends what it says, depends what the doctor's prepared to say, and depends what the evidence is in front of the doctor. Statement from refuge could be very strong evidence. Statements from friends and witnesses probably less strong, but they do have some value. That's really the best advice I can give because every case is different, but most certainly the applicant should provide whatever documents they can.
Sure. And another query from a person who is in the UK as a partner of an EEA national who holds pre-settled status.
Yes.
And this person says, I'm a victim of domestic abuse. I have submitted my application for ILR based on this basis. I'm not sure how long is the processing time, and I also want to find out if I'm allowed to work meanwhile my application is in process.
What visa did they hold immediately before they made the application?
They have also got pre-settled status, the 5-year visa as EU national family member.
Yes, they still hold pre-settled status today. The way that it works in UK immigration law is if you hold status A and you apply for status B, until your status B application has been processed, you still hold status A, and whatever rights accrue to that, you still have them. So it can still work.
Okay.
Do you know how long ago he submitted the application?
He hasn't mentioned.
Well, normal processing time is something like 6 months. If he hasn't reached 6 months, probably it's too early to worry. If his application appears to get lost with the Home Office, as happens occasionally, they should instruct a good lawyer to put themselves on the record and try and contact the Home Office and try and chase up the application.
Great. That often helps. Brilliant. Just last question for today. A lady has contacted saying she applied for ILR based on domestic abuse. However, her application was refused. She also have British national children with her spouse.
Are they British citizens?
They are British citizens. Yes. And she wants to know if she can apply for any visa to stay in the UK based on her children.
She might be able to. Do you know how long ago the application was refused?
She's mentioned she just received the decision letter a week ago.
All right. I don't want to give too much detailed advice about that because I'd like to know a few more facts, but let me tell you, potentially she might be able to apply for a visa as parent of British child or British children. But
Okay.
she would need to take detailed advice about that, but I suspect that might be the case.
Sure. Lovely. Thank you so much for today's vlog, and we look forward to seeing you in our next vlog.
Thank you. The pleasure has been mine.
Lovely. Thank you. Bye-bye.